short and you need me to pop up. If you do, just let me know and I will. I had a PowerPoint presentation and we had some technical issues, so we don't really have it. I have it in my hand, but I have the only copy apparently in the room, which is fine with me because I don't really follow PowerPoints. I never get through them. I kind of use them as just kind of a talking points rather than what I probably end up talking about. And as he said, Zach and I do very, very similar things. We both are data privacy professionals. We're certified privacy professionals. I work with a lot of tech startup companies where we analyze the information they're taking in with their new apps, their new devices, anything that they're doing. We analyze that data, figure out the risk to that data, and create policies around it and governing documents around it. But how I really got into privacy was I started as a labor and employment attorney. I've been a labor and employment attorney for 15 years. And everyone's like, well, how do the two overlap at all, if at all? And they overlap because if you're going to have a security incident and you're going to have a data breach, it's because 85 to 90% of the time your employee lost your data. They took your data, they had it in a laptop, and they got their laptop stolen. They published it online. They were a nefarious employee, and they stole it, or some other reason. So I would always get the call, Sarah, so-and-so did this to our data. They published all these social security numbers online, all this financial data. Can we fire them? And the answer was like, yeah, we could probably fire them. We could definitely discipline them, write them up. But then the question became, well, what about all this data? What do we do with the data? And I was like, I don't know. And this is like 2010. And they were like, well, you're our lawyer. Can you figure it out for us? And my first big case was working for a large hospital system in Cleveland. And that's kind of how I started getting into the role, working with them on their HIPAA compliance, with their data breaches with respect to HIPAA, making sure they were compliant with the privacy rule and the security rule. So let's talk a little bit about, my presentation is on, it's kind of regulation, but I really titled my presentation is User Rights in the Wake of the Cambridge Analytica's Curtain Being Pulled Back. Because I think if we've learned anything in the last 60 days, 90 days, as we discover what Cambridge Analytica did, and the data that they had and what they took. And as we started getting privacy notice and updated privacy notice in the last 30 days, is that there is a lot of information out there. Information we couldn't fathom that was out there about us. We should have. They were telling us that this information about us was out there, that they were taking it. It's in their privacy policies, it's in their terms of use. But nobody's actually reading those things. But they were telling us we're taking your data and what they're going to do with it. We just weren't really paying too much attention, but now we've started to pay attention. So let's talk about first where we get our data rights. If you think back into 1990s, did you care much about what was going on really with your privacy? Not really. It was just, you went to the library. I mean, you didn't have to fill out terms of use when you went to the library and you took out a library book. You didn't have to fill out a terms of use whenever you subscribed to cable or when you got a TV and wanted to watch TV. Now try to do that. Now try to get a Roku or your Siri hooked up or get a Kindle or go on the internet and download any type of media, and you're going to fill out and consent to all kinds of things that you never would have even been fathomable in 1990 when we didn't have digital media. So where do we get our rights to these things? How are our rights actually created? The information is only out there if we put it out there. But how then are we protecting that data? We're starting to see a little bit more protection. The GDPR is certainly something that has kind of triggered in everyone's mind that this data is valuable, this data is out there, and there are ways to protect it. Now, as Zach already said, we don't have a federal statute that protects the data. We have this weird patchwork of laws that cover by states. We also, though, have these industry-specific laws. So let's go back to our first real big privacy law, where we first started denoting privacy and rights with our data. And where did that come from? That came from the 1996 Health Information Portability, the HIPAA high-tech. We started finally protecting our health information. So we do have these industry-specific laws. Now with HIPAA high-tech, we protect information in two ways. We protect it with the Privacy Act, the privacy rule, and the security rule. And that was the first one that we really had. And one thing that's really interesting is when I work with my European clients that are developing their technology versus my American clients who are developing their technology. And one thing to understand is privacy in the rest of the world is very, very different than it is in the United States. Everyone's like, oh, the GDPR, it's this new thing. It's this new wave of privacy, never been seen before. That's not true. The GDPR replaces a law that was in place 20 years ago. It replaces the privacy regulation of 1996. So the EU has had these privacy regulations in place for 20-some years. We just didn't know it. Whenever you see that little unsubscribe thing at the bottom of emails, it's derived from that law. So we've had these privacy protections in place in other countries and other parts of the world, just not the United States. But we did start with Ferpa. And I think that's probably the best place to start, where we actually started learning to protect our data, our healthcare information. Then we had the Gramm-Leach-Bliley Act. And why did we care about that? Well, we cared about that because that was our financial information. That is what protects your financial institutions. And one thing that I think is really, really interesting about Gramm-Leach-Bliley is I say it covers financial institutions. So then I have a lot of people start ignoring what I'm saying at that point, because they don't think I'm talking to them. They don't think it applies to them. Because in order for you to be compliant with Gramm-Leach-Bliley, you have to have certain measures in place. You have to have protections in place, like incident response agreements, incident response plans, and other things in place before you can actually collect and use that type of financial information data. But everyone thinks I'm talking about banks, and I'm not. Financial institutions is extremely broad. Anyone who's giving any type of line of credit, your CPAs are all covered under it. Anyone who does any type of loans, any mortgage lenders are covered under it. And a lot of them don't realize that they were covered under Gramm-Leach-Bliley, so they're not complying with the law because they don't know that it actually applies to them. So that's giving us another layer of protection, all right, with these federal regulations. I'm going to take a peek at my slides to see where I was going with stuff, because you'll see I go off on tangents quite a bit. So then who else did we need to protect? We're protecting our health information. We're protecting our financial information somewhat. What else are we going to protect? The vulnerable population, all right? Minors, right? And he talked to you about COPA, Zach did, about how we protect children's online privacy, and you cannot collect information about minors under the age of 13 without parental consent. That ties a little bit into Ferpa, which is the act that protects your educational information, your education records. So those overlap a little bit depending on the data subjects and whether the data subjects are under the age of 13 or not. So we started layering on more and more protections. And Ferpa is there are some exclusions to Ferpa. It is subject to the FOIA Act, so the Freedom of Information Act, where you would have to redact some information if somebody wanted it, and also to state Sunshine Act laws. Like Ohio has a Sunshine Act, like an open records law. So if you want information and you can't get it through FOIA, it might be under the Ohio Open Sunshine Records Act law, and you can get the information that way. So we started protecting that way. We also protect certain email through our CAN-SPAM Act. Canada has a very similar one. We started protecting through the TCPA, which is protecting you against getting junk faxes and spamming of those sorts. We also have these patchwork of state data breach notification laws. And one thing that Zach was saying, and it's very, very true, we talk about personally identifiable information and what is actually covered. And the interesting thing about the whole thing is it depends on what state you're in. It really does. And you were talking earlier about there is no big agency that's doing this. These are all just these different laws, and it's really hard for business owners because what is legal in one state and fine in one state may be very, very different in another state. Zach was great because he said, you don't say the B word, you don't say the breach word. You say security incident until your lawyer tells you it's a breach. The other thing that comes with breaches in these 50 different states is a lot of times my clients are really confused. So right now, just now, in the past 60 days, we finally passed laws where every single state has a data breach notification law. But that just happened in the last 60 days. Georgia was the last holdout, right? Well, say that you had a company that was in Georgia before the last 60 days, and they have a breach, a security incident, and they come to me, and I'm like, well, we need to look at this. They're like, this data was lost and this data was lost. They're like, well, we don't have to do anything because we're in Georgia. We don't have a breach of data notification statute, right? No, wrong. That's really wrong. Like, no, because you have to look at the data subjects. And it's the same way that we look at the GDPR. It's where the data subject actually is. It's where the data actually is. And here, if the data subject is in, and they had data subjects data, their customers. It was customer data, and it was in Florida, and it was in South Carolina, North Carolina, and all those states had data breach notification laws. And so that's where the data breach notification laws goes. It goes by resident data, and so they were covered. Now we have the GDPR, which replaced the privacy regulation of 1996. And we have it. It came into effect in May 25th. And I've had clients all over the spectrum on this thing. I've had clients who really want to comply. They know they're being hit by it. They've got 80% of their user data is EU. Some of it's only 50%, and some of it's only 5%. So really it depends on how much money they want to dump into compliance, depending on how much user data they actually have from the GDPR, from the EU, from the EEA. And I've gotten some clients who've just yelled at me and have said, they've been very angry at it. When you tell a client that they're going to have to spend thousands and thousands of dollars coming into compliance on something, they say, how will they even enforce this against me? I'm a United States company. I don't have anything over there. They can just try to get me. And I've had clients that are like, we're just not doing it. We're just not going to do it. So there's been like 4, levels of compliance with the GDPR. We've had the ones that are very compliant, who we're doing the data processing analysis. We are registering, getting them the DPO appointed. We are registering them in the EU. We are registering them in the different member states that they are in. We're doing all their privacy policies. We're changing them all out. We're doing all their new consents. We're sending all the privacy emails to everybody. We're also having the ones where they're doing partial compliance, just enough where they're not going to hopefully get caught. And that's probably what a lot of people are saying. And I'm getting a lot of calls now where people are like, I need to comply with the GDPR. I need to update my privacy policy. And that's all they want to do, is just update their privacy policy, do something that's on the face is going to look like they're doing something. And I'm like, well, that's fine, I can update your privacy policy, but that's not exactly what the full compliance looks like. And then you have some that say they can't come and get me. I'm in the United States, and all I have is a website where people buy products through my website, and they just don't want to comply at all. So I have these different phases kind of compliance, but those type of different laws are showing you kind of where users are getting their rights. Okay, the laws that are building up user rights and how you enforce those rights. You enforce the GDPR rights through the EU, through the supervisory member states. You can enforce your rights on healthcare information through the HHS OCR, which investigates that. Other rights, if there's a privacy policy that they write and they breach a privacy policy and it's a company, the Federal Trade Commission is going to enforce that. Then you have laws that have your civil compliance, where you can just file a civil lawsuit and they're going to take care of your rights. So we have these statutory laws and we have regulatory laws. We also have the common laws that Zach was talking about, where you're in a public space and do you have a reasonable expectation of privacy or not? And a caveat to what he was saying about when you attend a conference and you don't want them to use your images. And one way you can do is kind of put the implicit consent in a notepad. Other ways that we've worked with clients on this is whenever someone does a name tag, if they pre-consent to having their picture taken and used, they get a certain name tag, has a color on it or something, so our photographers can tell. We also have done it with different placards, like lanyards that they put around their neck. One issue we have is with children. And so when we have children, I work for some daycare facilities, some like camps for children. And one thing that we've done with children is they take pictures of everyone's kids and they post them on Facebook and things like that, and they may use them for their marketing materials. Well, a lot of parents do not want images of their children out. And so what we do for that, we can't put name tags on the kids. The kids are going to lose them, right? We put little colored bands on the kids who can't have their identities out, and they are taken out of photos, not photographed with pictures. But it is becoming a big deal. But that is where our rights are coming from, how we're building our own rights and how the legislators have decided and the courts have decided that we have rights. How do we lose rights? We lose rights through certain contracts, and we lose rights through certain interpretations of the law the courts are giving us. So let's take, for example, the recent case law last week. Okay, we had a major privacy decision last week from the Supreme Court in the Carpenter case. The Carpenter case is really, really interesting because it was about your cell phone location data and how you can get that information. Because here's what you need to understand. If you've done it online If you've done it on a phone call, if you've done it on a text message, if you've done it on a computer and you've clicked and you've clicked and you've clicked through website to website to website, your information was collected. Someone has it. And if you just have to think about it. And if you've ever, I would encourage anyone to do this. When you go home on Facebook, go through into Facebook and download your information. Do it for yourself. It'll run you through a battery of questions. But there's 3 different ways to get your own information from Facebook, and they will give you certain categories of information. They're not going to give you everything they have on you, because that would take forever. But they will give you so much information on yourself. Everything you've done, every conversation you've had, everything you've deleted, every friend you have, every friend you've deleted, every conversation, every page you visited, every interaction. They'll provide it to you. Mine is staggering. It's pages and pages and pages and gigabytes of information. Then they provide it to you in a zip file. But that's the information they choose to give you. That's not everything they have on you. And that's what you have to remember about every single company that takes your information. They have it all. It's just how much they decide to give to you or how much they decide to give to somebody else. And the way they communicate that to you is through their terms and conditions. Those contracts that the lawyers write, that I write, that nobody reads, ever. They're painstaking to write. And I saw this meme, and it's in my PowerPoint, but it's not here. And it is a meme, and it is the definition of, it's on hip something, whatever. It's like terms and conditions. It's a noun, and it means we could literally write anything here, and you wouldn't read it. So we decided not to bother. That makes me feel really good about what I do all day. I'm like, this is amazing. Like, my work is worth nothing. But my work is worth a lot to the companies. Because billions and billions of dollars are lost by people every year because they sign away their rights to litigate. They require them to arbitrate. They give up rights to their image. They give up rights to their own copyrighted material. And I'm not kidding. Here's some things that people give up. And let me go back just one little second to 2001, because we started trying to get more privacy. We did. We started to care a little bit in about 2000. There was even some laws that they were being proposed, because we're getting more cell data. Cell phones are becoming a big thing. So everyone's like, we're going to have to do something about this. But then this thing happened, 9/11. And then this other thing happened a couple months later, the Patriot Act. And national security concerns took over. And so all those laws that were proposed on privacy went to the wayside in the name of national security. And so when I say court decisions, and I talk about the Carpenter case that came back out last week, what we've been doing is our privacy was gone. They're taking everything out of our phones. They can do whatever they want with our data. Courts were having to claw it back. We're clawing back our privacy as citizens, clawing it back through court decisions, clawing it back through demanding legislation, data breach notification, so that we know when our data's been lost. We're clawing our privacy back. We're saying, look at the EU and what they've done. That's not a bad idea. We didn't really listen to it in 1996 when they passed it the first time, but now we're up and paying attention. We like our privacy now. Because one thing we're learning about privacy, and we learned it through Cambridge Analytics, because we're not paying for Facebook. But now you know, if you're not the consumer, you're the product. We all found out a couple months ago that we're products. And I don't want to be a product. You're going to pay me for my product. You know, nobody wanted that information out, and it's just giving it away, and it is valuable and it has value, but no one's collecting on it except the companies that have it. So let me tell you a little bit about some of the terms and conditions that are real. These are real things. And if you would, these are some statistics and some facts. If you were to read everything you agreed to, it would take you 1 full month of work out of your life every year. Yeah, just think about all the stuff that every website you visit, you're signing up for their terms and conditions because they're implicit. Because they say, if you continue to use this site, you are agreeing to all of these things, these litany of things. That's what they say. GDPR says you can't do that to people anymore. Okay? That's what the GDPR, but it doesn't, here's the thing about GDPR, it doesn't apply to us. We're here in the United States. It doesn't. Unless we were in the EU, it wouldn't matter, right? So some companies have started making everything GDPR compliant because they think it's going to be the next wave, and they think if we tell our customers that we are GDPR compliant and we're going to give you more privacy, you're going to start using us more. And so we are seeing a lot of companies that are doing that. But customers lose $250 billion a year due to stuff that's hidden in the fine print. And here's what I mean by that. On LinkedIn, if you read LinkedIn's terms and conditions, you grant them a worldwide transferable and sub-licensable right to use, copy, modify, distribute, publish, process information and content that you provide through their service. Anything you write, anything you publish, anything you do on their site is theirs. They can do whatever they want with it. They can monetize your information. And that's another thing when we talk about rights that we have and what is protectable to us. We have copyrightable things too. When I post on LinkedIn, I post articles that are owned by my law firm, or they are blogs that are owned by me. Those are my copyright. Because when you create something, you don't have to register it to it be copyrighted. It is automatically copyrighted to you. Now, you can take steps to copyright your material. It's not that hard. You can just sign on. You can get an account right now through the Copyright Office, and you can start copywriting all your stuff and getting a formal copyright on anything you want. You don't have to, though. And on Instagram, here's one thing that you need to know, and this is from the revenge porn line of cases, which is sad that we have those, but we do. So whenever someone takes a picture, and this comes from Instagram stuff, if anyone takes a picture of you, or they take a picture of anything, who owns it? Well, it's not the person who owns the device, it's the person who clicks the picture, because there's an artistic element to it. So whoever takes the picture, even if it's on somebody else's phone, whoever hits the click or whoever hits it is their copyright now. That is now theirs. So what, you see how far LinkedIn is? Well, let's listen to what Instagram did. Instagram was bought by Facebook in 2012 and became a Facebook brand. Well, in 2012, Instagram changes their terms of use. And they came under fire for its policy that said that if you used Instagram, they would have the right to sell any posted information for their own advertising. Anything you posted was theirs, and they could sell it. The problem was that a lot of people use Instagram for marketing. They use it to sell their own products. They use it to sell their own art. And these people threw a fit. And they demanded that this be changed or they were going to boycott Instagram. Well, that worked. And Instagram changed their policy, and that is no longer the policy. But it's because people were cognizant of it. It's because somebody said, hey, absolutely not, you're not going to do this. And enough people said they were going to boycott the brand in order to get what they wanted, and it worked. It doesn't say that anymore. The funniest story I have on terms and conditions was in 2009. It's a European company too. European company called Game Station. So it's like our GameStop, and you can order a bunch of their games and gaming consoles online. Well, in 2009, they revised their policy, their terms and conditions. It said, by placing an order via this website, you agree to grant us a non-transferable option to claim, now and forevermore, your immortal soul. 7,000 people lost their souls that day in that exercise to determine whether people actually read these things or not. So it's funny, but it's real. Like, it really happened. They really did it. 7,000 people signed up on it. It's showing that we do not read anything that we sign. So here's one thing that's really interesting about AT&T. And if you're not scared about your soul from a gaming company, because you're like, I don't do that stuff anyway, listen to what AT&T says. We can use data to investigate, prevent, or take action regarding illegal activities. I was okay with it until I got to the prevent part. Prevent? What do you mean you're going to prevent? Because that looks like, that's not reactive. I'm okay with a reactive something. Like, I do something, you arrest me, you have probable cause, you get a warrant, you go after and dig for stuff. AT&T has a policy that says they're just going to start preventing crime? This isn't Minority Report. This isn't a Tom Cruise movie. How are you doing this? they were giving the government under the Patriot Act can take this data for anyone that they want to monitor on a terrorist watch list, on a do not fly list, sharing information to prevent crimes. And by signing up for AT&T, you agreed to allow them to use your data in that way. So why did we start caring a little bit more about privacy? I got to watch my time here. Okay. We started caring about privacy about 2012. We really started caring. Why did we start caring? Well, we started caring because we all love Target, and Target had this enormous breach, and they lost all of our credit card information. All of our Target card information was gone. So we cared a little bit. That's when we first started getting the notices, right? That was the first time we were like, what is this stuff? It's data breach. Right, well then, Home Depot, same thing happened to Home Depot. Like, all right, I don't really care that much. I'm not really a DIYer at my own house. So maybe this will all die down soon. It didn't die down, it got worse. Next, we had Anthem. Why did we care about Anthem? Well, I didn't care about my credit card information so much because I can just get a new card, right? I just cancel it, get a new card. They're gonna pay for my credit monitoring, fine. Why do I care about my health data? Because I can't change it. My health data is my health data. It is what it is. And it has more value on the black market. A social security number, I can get 50 for like 10 bucks on the dark net. Now, if I want a profile of someone's health on the dark net, I have to pay 50 bucks to get someone's health information. So it's a whole other game changer when we're talking about healthcare information. And Anthem not only hit their clients, it hit their employees as well. Everyone's health information was out there on the dark net. We also cared whenever Yahoo got hit. That was a big one. People are in our emails now. Now we know people can break into our emails and get stuff out of our emails. And then Sony got hit. We found out it's not just about credit card information, and it's not just about financial information, and it's about corporate trade secrets and corporate espionage. And holy crap, stuff got really, really scary now. Now we have Angelina Jolie mad because she found out somebody doesn't make as much as she did. That's, protected data. These movies are getting released. And they have monetary value. Things are being released that now these companies cannot sell because they were released without them having to go through the theaters. So that was another wake-up call for us as a country, I think. And the next one, we had Equifax. And Equifax was a big game changer because if you've ever pulled your Equifax report, and I pull them all the time because I do background check law. I do Fair Credit Reporting Act stuff all the time. I defend class actions for that kind of work. So I'm pulling this kind of stuff all the time. And what we found out there is that Equifax has everything. TransUnion, they all do. Experian, they have all your mortgage information. They have all your criminal records. They have all your misdemeanor records. They have everything. Now, whenever someone does a background check on you under the Fair Credit Reporting Act, which also protects your rights, they only give so much information. They'll give all of your felony information to your potential employer, right? They won't give your misdemeanor information. They'll only do your criminal. They will do your bankruptcies, going back 10 years. They will do your liens, depending on how long ago you paid them. But there's information they won't give. Well, guess what? The hackers didn't care about that, and it was all up for grabs. You apply for a mortgage, your financials went out the door, because that's how they supply that information to the banks. So that was scary. And then the worst one that I think everybody really freaked out about was, well, it was sensational too. I mean, and Zach talks about it, and that was the Ashley Madison breach. And Ashley Madison was a real game changer because we found out that information we put on websites, when we went on websites, it wasn't just companies losing our credit cards, it was companies now losing that anyone could hack into a website, and any information we put on a website could be found out about us. And the information can be really, really embarrassing. People put their, sexual preferences and things like that. And the hackers, it was an espionage. I mean, it was a malicious attack because they had said on their privacy policy, because one thing about Ashley Madison, and the attackers are smart, and they're funny sometimes. They really are. Like, we're going to go after the bad guys, really bad guys. And we're not even going to seem like the bad guys because we're going to expose cheaters. And who's worse than cheaters? People who kill puppies. That is like as low as you get, So they're like, we're going after these cheaters, and we're going to make a point. And the point was, for an additional fee. So not only can you cheat on your spouse for a certain amount of money, But for another level of money, we will make sure that all your information is protected. The problem was the hackers got in. And the hacker said, you are promising your customers 100% anonymity if they pay this an additional $14 a month or whatever. And that's not true. And you need to tell everybody that your policies are wrong and that you cannot guarantee their anonymity or we're going to leak all their information. And Ashley Madison called their bluff. And Ashley Madison lost really bad. They did get all their data, and then they published their entire list of clients. And that's where we found out that any website that we put data on can also be hacked very, very easily. And the hackers do it for fun. They hacked Sony probably for fun, probably a little level of corporate espionage, and they hacked Ashley Madison for fun. And people were like, what do you see as the next big wave of data invasion? Internet of Things. I think we're going to see it in a different realm, right? Let's talk about cookies for a minute, and I'll tell you what I'm talking about. We talk about cookies and how, you search for one thing on one device, and then the next day it shows up everywhere. And you're like, how did it know? How did my phone know that I was looking at this dress, or I was looking at this piece of furniture? Now, everywhere I go, I can't escape this thing. And it's these things called cookies. I think they should be called potato chips. Because, there's not just one. You can't have just one cookie. You got a million. Because when I write a cookie policy, especially for a marketing company, that thing, I list all the cookies. I write the good ones. I'm like, these are what web beacons are, and these are what these are, and these are the ones that we're using for you. We got Google Analytics, we got Facebook Analytics, we got Instagram, and these are all the cookies we're using. And here's what they are. These are persistence, or these are permanence, or whatever. But they're pages and pages. They are long now. When I started doing privacy and started writing policy, it took me 3 hours. They were like, Sarah, how long to write a privacy policy? 3 hours, about 3 hours of legal work. This is how much it's going to cost you. Now, it's a lot. There's a lot more disclosures that we make that I require my clients to make. If a client comes to me and wants an itty-bitty privacy policy, I'm like, you're with the wrong lawyer. You need to go to somebody else. We are going to tell our customers exactly what we're doing with their data. We're going to be very, very clear about our data. That's the company we're going to be. If you want to be different, you can go somewhere else. But I want to be very, very clear. Say exactly what cookies we're having, what we're running, and show them exactly how to opt out of those cookies. Because I don't like to be tracked. I'm tracked on everything. And I tell people how to do it now. But I do think they should be called potato chips because literally there are a million of them. On every application you run, you get a million of these things, and you kind of can't get rid of them. So I think what we're going to start seeing is, and we saw this a couple weeks ago, not a couple weeks, probably about a couple months ago. Remember the case where they found out that Siri was listening to the conversation? Yeah, I think that's the next thing. That's what we're going to see. Siri's not going to. I do a lot of work, and one thing I can say is, I know the technology is out there. It's just how people are using it, because I have some really cool clients, all these new startups and all this new technology. We're doing the finger chipping. We're doing the biometric data. We're doing the face recognition. We are doing these sensors in, places of public accommodation, or in homes, or on vehicles, or on menu boards, to the point where if you walk you drive through a certain restaurant, there is a device on that menu board that reads your device in your phone, your MAC address from your phone, and it knows exactly what you ordered last time you were there, in any one of their restaurants, because they identified that MAC address. It doesn't scramble anywhere. So you can go to this restaurant in one city, go to it in the next city, it reads the same MAC address, knows that you pulled up, knows what you ordered last time, and it will make now targeted ads to you. So if you got a number 2 last time, it'll tell you that they're running a special on the number 2. When I said, are we in Minority Report? We are. We're this close to being in Minority Report. Remember the Tom Cruise movie where he's walking into a Gap and it's like, hey, you nice jeans. If you haven't seen that movie, you have to go back and watch it, because I think that's where we're turning. And I think the next breach we're going to start seeing and hearing about is going to be the breach on the Internet of Things. We are going to learn that, yes, Siri is listening to us. Siri is collecting our data. Siri is transferring our data. Our Echo Dots are things like that. The other is going to be in the Internet of Things also with connected devices. I think as we start, and I work for a lot of real estate developers too. So we will take on a real estate building and we will figure out what people want to live in, like how people want to live, how businesses want to run. So we will have all the heating centralized, run by apps. People in their homes, they can turn on their, through their Nest apps, but we were doing it with full building amenities, that they can go in and set their heat, set their water, set their alarms, set everything. The problem is going to be is they're going to be able to breach those. You can ruin someone's life with their temperature. I mean, if you want to mess with somebody right now, just like turn their heat up and burn them out. Or in the winter, turn their heat off. Turn their air conditioning on and freeze them out. They have the Sonos systems, the Bose systems that play the music. Turn them up loud and never be able to turn them off. You'll drive someone crazy. I don't know if you guys have seen it. I watch a lot of TV. I should probably stop and read more books. But if you've seen iRobot, if you haven't seen iRobot, watch it, because that's exactly what happens. There is a corporate, she's a general counsel, she lives in this high-end apartment, and that's exactly what they do to her. They're trying to get to her, and they basically hack her entire smart apartment. She has scalding hot water for a shower, can't turn it off. They're burning her to death. Her sound system is cranked all the way up, and I do think that we may start seeing attacks like that. I think those will be the ones that we start seeing, little attacks like that. I think we'll also start seeing them on different infrastructure, like any plants that are run through the internet. I think we'll start seeing attacks like that. But the one thing I can tell you about your own data is whenever you're going to get more control over it. Like I said, we're clawing it back. I would encourage you to claw your own privacy back. Whenever you're going on a website, pay attention to the terms and conditions. Determine who you want to do business with. You are the consumer or you are the product. Figure out which one you are, but more important, make a choice about what you want to be, what you're doing with these companies, and who you want to do business with. Because the companies that are going to survive and the companies that are going to move forward are going to be the companies who are going to value your privacy. They're going to tell you what's going on, what they're doing with your data. It's not going to be the companies that hide behind it, because a better model is going to come along and take them over. And people are going to choose to do business with those companies instead. Look at your terms and conditions. And now we're seeing so many more websites that are saying, look at our updated privacy policies, and that's thanks to the GDPR. Read them. If you get the opportunity to turn off cookies and you do not want all these targeted ads, turn them off. When you get emails and it allows you to unsubscribe, unsubscribe. Unless you don't care and you want marketed to. And then by all means, keep those things. But understand what your rights are. I think in order for us to, move forward, we have to know where we are. And I think we've had our heads buried so long that we're now, especially with 9/11, we went, as a country, with this amazing shock of something that had never happened before, where we were looking at, we have to protect, ourselves and monitor people. But then it became, it's monitoring us. And we weren't the terrorists, right? So everyone now is feels a little bit like it went too far. So read your terms and conditions, opt out of your cookies. Just know that, and whenever, take your privacy seriously. When you see stuff about privacy and you see new laws, write your senators. Make it a talking point. I think you're going to start seeing it a lot more. I couldn't be more busy in my practice than I am right now, between privacy policies, litigation, attorney general's enforcement actions, HIPAA enforcement actions, and then the Federal Trade Commission actions with respect to privacy. And then not only those enforcement actions, but with my clients who are really good at technology, who are coming up with some really amazing, scary stuff. That's all for me. Thank you.
Thank you so much.